Hello, everyone, and welcome to today's presentation titled July is the New January. New state laws do not take the summer off. We are thrilled to have you with us today as our presentation will be an insightful and critical discussion on upcoming policies that may greatly impact your organization's compliance strategy. Now, I know that these are important to you because we've had over 4,000 people sign up for this webinar, so I'm thrilled to have you here and thank you so much for your time. My name is Michael Worth. I'm the Vice President of Sales at ComplianceHR. I've been with the organization since it was founded over 7 years ago, and I'm honored to be here today along with our presenters from Littler. Before I dive into the content, I'd like to introduce you to ComplianceHR and our Navigator suite of solutions. For those of you who are not familiar with ComplianceHR, we are a unique joint venture between Neotologic, which is an artificial intelligence, and Littler Mendelsohn, the world's largest employment law firm. ComplianceHR delivers expert employment law guidance in a fraction of the time of traditional methods. Our goal is to simplify the complexity of employment law, something we will learn a lot more today during our presentation. So we have a variety of solutions designed with expert content from Littler to assist you with complying with employee handbook policies, wage and hour questions, paid leave, COVID, and many other labor laws. Our objective is to help your compliance strategy to become proactive instead of reactive and streamline your HR and legal workflows. But today we're going to talk about our most popular application, PolicySmart. PolicySmart has been our most heavily used solution over the last 2 years because it contains a comprehensive library of customizable federal and state-specific model handbook policies, policies checklists, proactive policy news, timelines, and updates, so you're never behind schedule. You know things long before they change. This map represents why PolicySmart was our most popular application in the last 2 years, and thanks to the tireless efforts of Littler Knowledge Management Team, PolicySmart is always current. And what this map shows is that over a brief 4-month period, there were significant changes across all the different states. And if you're trying to keep track of multi-state compliance, that can be a very daunting task for folks. My clients tell me that our bi-monthly reports are their favorite PolicySmart feature. When you subscribe to PolicySmart, you'll receive automatic emails that include new developments in the states that you are tracking, as well as what developments will be taking effect in the current month with links to the news. And effective dates are never missed. These are tools that really help you stay ahead of the quick changing rules. All right, we have a lot to cover today, so don't worry. We'll send you the presentation, a link to the recorded audio, and please sign up for a ComplianceHR demonstration and add any questions you have to the Q&A box. If we don't have time to answer the questions at the end, we'll compile a list of all the questions and send them out to you at the very end or later this week. But what's important, listen, if you're really serious about compliance and you're interested in simplifying the complexity of employment law, please schedule a brief demonstration with me and my team. We'll discuss your requirements, we'll review Navigator Suite functionality, I'll even share compliance methodologies that were successfully deployed by other organizations and even give you a free trial to see how it all comes together. So without further ado, let's get to the real reason why you're here today. I would like to introduce you to today's presenters, starting with Joy Rosenquist. Jo has litigated matters in state and federal court. She has practiced labor and employment litigation and advice and counsel work. Joy also provides advice and counsel on employment law issues, labor implications, reasonable accommodation, leaves of absence, and discipline termination best practices. Welcome, Joy. And joining Joy, we have Gbujama, who focuses his practice on advising and representing employers in all aspects of labor and employment law, delivering quality client service, and enjoys working collaboratively with clients to devise creative, cost-effective solutions and positive outcomes. He has a passion for assisting employees in promoting diversity, equity, and inclusion in the workplace. A warm welcome to you, Jo, and with that, I'm going to pass it over to Joy.
Well, good morning, everybody. I am excited to be here with you all. I am Joy Rosenquist. I'm special counsel with Littler Mendelson, and here with my co-presenter, Joe. And we have divvied up the agenda today. You're going to hear my voice for just quite a while until Joe jumps in. But Joe, do you want to go ahead and say hi really quick so people know what you sound like?
Hello, everybody. It's a pleasure to meet you. This is Joe Gbujama, and I'm an associate with Littler's San Francisco office.
All right, thanks, Joe. So let's get started. As you can see, we have quite the full agenda here, and we're just going to go ahead and get started on agenda item 1, which is contingent workforce, as you know, classification of employees versus independent contractors. So here in California, we're going to start our presentation today on AB 5. And California has really set a precedent in classification of independent contractors. And a lot of what you will hear today are California cases and statute or our state Supreme Court decisions. And that's not because we think California is just so important. It's because California really sets a barometer for a lot of other states that kind of track our legislation. And a lot of California corporations, as many of you know, are nationwide. So if you have to abide by the certain law in California, you know, chances are it's going to follow suit in other states. So without further ado, AB 5 is an interesting phenomenon here in California. So in 2018, we had a Supreme Court decision called the Dynamex case. And essentially it flipped the classification of what is an independent contractor presumption in California. So in California, we codified that into state law with Assembly Bill 5. Essentially means that we made a Supreme Court decision our statute. So instead of the prior classification determination, which was you're an independent contractor unless you meet certain categories, we've now flipped that presumption in California to say you are presumed an employee unless you meet 3 criteria. Those 3 criteria, they look simple, they are not, they're difficult to meet. So that first criteria is that you're an employee unless your worker is free from the control and direction of the hiring entity in connection with the performance of the work. And B, this is the stickler, that the worker performs work that is outside the usual course of the hiring entity's business. This is the problematic prong, which I'll go into in a little bit more detail. And that the C part of this test is that workers are presumed employees unless the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed. So we'll show you kind of a timeline here. Of course, there was a legal challenge to AB 5. There are still legal challenges to AB 5. The most notable one, the one you've probably heard in the media, is the California Trucking Association, which got a preliminary injunction from enforcement of this law in 2020, but it was overturned a couple of years later. So they did something fairly unique, and they appealed directly to the U.S. Supreme Court for review. So the Supreme Court asked the Solicitor General for input. So the Solicitor General is your federal representative before the Supreme Court. And essentially the Solicitor General in this case said, no, leave AB 5 alone, let California work it out. The statute's fine. You can imagine how many objections there were to the Solicitor General's input. So ultimately, the Supreme Court made the decision to decline or hear it. In this case, they just decided a couple of weeks ago to decline to hear the challenge to this law. So by declining to hear the challenge to AB 5, not only did the Supreme Court send a message to this particular industry, basically saying, work it out, they sent a message really to the states, you know, to say, here's your legislation, make legislative workarounds. So now that the injunction was lifted, this is immediately enforceable. The concern here is our supply chain. You've seen this nationwide and quite especially in California for those of you that operate trucking companies or any goods that are sold to the end user. So the California Trucking Association is concerned that drivers are going to opt to leave their jobs rather than be classified as employees, and that this is going to exacerbate the driver shortage. So right now, the legislature is in summer session, and when they come back August 1st, Governor Newsom has a letter on his desk from the Assembly Republicans, according to a recent news source here in Sacramento, that essentially says, look, the fate of the trucking industry and our supply chain in California and across the nation really is in your hands. You need to have cleanup legislation to make AB 5 workable for this industry. Separate, and I don't have a slide on this, I just wanted to drop a quick note. Many of you have probably heard about Prop 22 in California. This was a voter initiative that passed with pretty overwhelming support to exempt app-based drivers from AB 5. So we're looking at Uber, DoorDash, Instacart, etc. So although Prop 22 said, yes, exempt them from AB 5, we don't want this model to change, a court in Alameda found it unconstitutional for a few kind of technical reasons. So just last week, July 13th, last Wednesday, Uber is keeping their appeal alive, and there was oral argument in the Ninth Circuit to continue to exempt Uber from AB 5. Now, other app-based companies have struck individual deals with the legislature, so rather than leaving California, a lot of them are getting tax-based incentives to stay in the state. In fact, the governor has an entire department dedicated to that effort in California. So let's hear about some non-California updates, okay? So this is an interesting law. Florida has a new classification law that essentially deals with an employer during a public health emergency. They may take certain actions that may help individuals, but they don't want those actions to be used against them in a civil case, arguing that they are misclassified and should be an employee instead of a contractor. So what are some of those actions employers are taking that Florida does not want them to be held accountable for in this classification? COVID testing, providing PPE, taking any action to protect, the health and safety of those individuals, or having to abide by an ordinance or a public health order, et cetera. So this Florida SB 542 says you can do all of that and not have that be used against you on a misclassification case. Now, Seattle in Washington has a new bill. This is the Pay Up bill. So this has gotten a lot of media attention. This is really interesting. Seattle in particular, and this is obviously a local law, not a statewide law, but the new labor standards requirements for contractors in this bill has essentially hiring entities have to provide certain terms and conditions up front if they're hiring a contractor, and you need to advise of wage information for each wage payment. So not only do we have new disclosure obligations, but it's a new wage payment for gig workers. So the Pay Up bill essentially increases wage and mileage requirements for on-demand gig workers. This essentially requires companies to pay per minute and per mile rates to delivery drivers on apps like DoorDash, Uber Eats, and Grubhub, very popular in the Seattle area. So once that driver begins to accept an order now in Seattle, those minimum wage requirements are going to kick in, and that gas mileage reimbursement is going to kick in. So this new law, it doesn't go into effect to 2023, but it is interesting in that it's designed to allow contract workers to earn that city's minimum wage of $17.27 an hour for those gig workers. And we did get just a quick comment here from one of the attendees asking, why so much California content? And the reason really is because a lot of the California content, not only does it serve as a foreshadowing of other states' activities of what's coming down the pipeline, but it also is important because a lot of these California corporations are nationwide. So even if you're with a company in Florida and your corporation is also in California, as in-house counsel or external, you're going to have to find a way to comply with these California laws. That takes us to our second topic today, which is also a little heavy in California as well, but I promise there are other state updates which are equally interesting. This is a big one in California. Let's get started with this new Supreme Court decision. Naranjo, it was a security guard employed by Spectrum Security Services. So what Mr. Naranjo did was transport prisoners to and from medical appointments or transport prisoners between custodial facilities. In this case, he left his guard post for a meal break. And you can do that, of course, but you have to have a written policy saying, hey, you need to work through your meal break and we'll pay you that premium. Here's the written agreement. So in California, that's what you've got to have. Now, Spectrum Security Services did have that, but not for a certain time period. So in this case, he got in trouble after leaving his guard post for a meal break in violation of the policy. So he didn't file a PAGA case, which we'll get into in a second. He filed a class action. And so the violation here is one that many employers are used to having to deal with, and that is, if you unlawfully deny your employee a meal or rest period, you must pay that employee an additional hour of pay at the regular rate of pay. So they filed a class action on that note. Now, both sides appealed for fairly technical reasons in terms of the plaintiff appealed because it wasn't deemed a willful violation, which would have gotten more penalties. And of course, Spectrum appealed on all other bases. So the Court of Appeal really agreed with Spectrum that although they violated the meal break law, they really didn't agree that this amounted to other violations of California law with regard to wage statements or timely payment of wages. So we just got the Supreme Court decision, which is pretty important, and less than 2 months old, so we're still giving a lot of advice on interpretation of this and how to comply. But essentially now, your missed meal break premium is considered wages in California. Therefore, because it's wages, it supports a waiting time penalty. It also will support a wage statement penalty if it's not properly on that wage statement as wages. So we do have some practical guidance here now that we've got these potentially costly penalties that are considered wages. So we're recommending that all employers, of course, you must enforce your meal and rest breaks, and you need to know when those premium payments are due. So a couple of stopgaps here you can get is that employees and supervisors should be reviewing their timesheets. Review those, make sure they're accurate before they're submitted. And then second, your internal payroll administrators, they should be checking those timesheets as well. And if you use a third-party payroll processor, many of those software programs do automatically flag and add an hour of time for a missed meal break or a late clocking out after 5 hours. Now there's a catch. Although the software may catch it, that doesn't mean the wages are pushed out through payroll. So make sure those two things are communicating. So we want to give a brief update on PAGA. This is the Private Attorney General's Act of 2004, and there are many iterations of this in other states. Here in California, we call it PAGA, and essentially this is a wage violation that can be brought individually or as a class. Now, the precursor to filing a PAGA lawsuit is that you have to give a notice to the Labor and Workforce Development Agency as an administrative requirement. So here's the penalties we've got laid out here. This is a pretty typical scheme here for the penalties. Now in California, only 25% of this recovery goes to the employees and 75% goes to the state because it's essentially the state deputizing private citizens to sue employers in place of the state. But of course, the attorneys do get their fees. Now, we are noticed the filings are, of course, up significantly. So here's some stats here for you. Over the past 5 years, from 2017 to 2021, we have seen a 25% increase in PAGA notices. So even if your company is out of state, if you are a nationwide company, you have no doubt had to deal with a PAGA wage and hour case in California. Now, with everything enacted, there was, of course, a legal challenge. So we did have a trade group, the Business Industry Association, which I'm sure many of you are familiar with, sued the state alleging that PAGA violated the separation of powers by deputizing those private citizens and having them take on executive branch functions. So the Labor and Workforce Development Agency is so busy that it admittedly is not getting to any PAGA filings. They have admitted that 99% of those filings are ignored and not investigated. So the Business Industry Association used that fact and tried to hone in on it, but essentially, appellate court district ruled that PAGA does not violate the constitutional separation of powers because that employee can't sue until it gives the state first chance. So the state is exercising their authority. So this was recently, just last Friday, the Business Industry Association filed a petition to the California Supreme Court. We'll see what the California Supremes do with that. So not only do we have statewide Supreme Court decisions going on, we've got local ordinances in wage and hour. This is a trend nationwide, especially in the bigger cities. Now, if the and it's not just the coastal states, it's happening in Denver, Chicago, the Twin Cities, smaller municipalities, and larger. And we're really seeing this as a sea change in terms of localities are enacting their own rules for their own people, which historically we have not seen. So a lot of municipalities nationwide, they are moving to pretty aggressively accomplish local minimum wages and establishing local offices to enforce some of these ordinances that we're going to talk about here. One of them is interesting, and this is really happening throughout California, but also in Washington as well. We're seeing some local municipal codes that are providing for protection of hotel workers, which are arguably more at risk since they work alone in individual rooms than other workers. So they now have personal safety alarms and quota limits on how many rooms they're not permitted, but required to clean, with a lot of disclosure requirements in there. And then in San Francisco, we'll go into this a little bit later, but they have their own ordinance now on public health emergency leave that's now paid. So we are seeing a lot of local trends. There was just recently another one in Los Angeles that we're going to see is going to be happening in other bigger states, and that is a new healthcare worker minimum wage ordinance of $25 an hour for healthcare workers employed for privately owned facilities in Los Angeles. So that's a trend that I think we're going to continue to see. All right, enough about that. So the National Labor Relations Board, let's switch gears here. This truly is a nationwide issue. A lot of interesting developments happening at the NLRB. Should not be a surprise, filings are up. During the first 6 months of this fiscal year, we've seen union representation petitions increase at a crazy rate, 57%. So for those of you who are not familiar, a representation petition is filed by an employee or a union, usually not an employer, but it can be, with a National Labor Relations Board field office to have the board conduct an election to determine if employees want to be represented by a union. This is getting a lot of media attention with the Starbucks case, which we'll go into here. Separately, in terms of activity before the board, unfair labor practice charges have increased. We call these ULPs. So ULP charges increased 14%. And that's essentially a complaint by an employee or a union or even an employer that they feel there's been a violation of the National Labor Relations Act. So to keep up with this demand, President Biden in his latest budget requested a 16% increase in funding. So assuming that is obtained, I think we're going to see a lot of activity nationwide for private companies dealing with NLRB issues. Taken together with the fact that there's a new general counsel, Jennifer Abruzzo, taking a fairly aggressive stance on behalf of the board. One of the issues that she is pursuing is to ask the board to de facto find captive audience meetings to be automatically unlawful and to violate the act. So in order to avoid that, she wants to make it the law, essentially, to ensure that employees are aware that if they are told to attend a meeting by their employer to discuss union activities, that those employees are aware attendance is not required. Otherwise, they don't get that. They're considered a captive audience. So that would be a violation of the act. In addition, and this is pretty big deal, in my opinion, is that she's asking the board to adopt a requirement that an employer recognize and bargain with a union that claims majority support. So for those of you that may be involved in nationwide companies who have had competing and contested elections that are very close, and you have two entities claiming majority support, that's going to put you in a bind. You're going to need legal counsel to guide you through that situation. So if you're not familiar with the complaint process, here's a brief overview of how it works. So a charge can be filed by a union, sometimes an employer, but usually individual employees or that union, and they're alleging wrongdoing. So once that charge is received, you have an NLRB regional office that will investigate those allegations. And it's a lot like the EEOC, where they will collect evidence, maybe interview witnesses, and request information from that employer. So after that review, they may issue a complaint if they find there's merit. Now, between the point where they determine that there is merit and they issue a complaint, many times the NLRB will reach out to that employer to settle. So you're probably thinking, oh my gosh, what can I do? We're always telling you what you can't do. Okay, you can gather facts. You can give facts. You can listen to your employees. You can't solicit grievances. So of course, as you can imagine, there's a fine line there. You can express your opinions to your employees about why you think it might not be in their best interest. So these are very general guidelines, and if you have specifics about these, reach out. What you can't do really kind of falls into four very basic categories. First one's fairly obvious. You can't threaten your employees or interrogate them, right? You can have conversations, but you can't solicit complaints. So there's a line there. You also can't make promises or inducements with your employees or the unions to kind of strike deals to avoid a union election. And then lastly, this is a little bit of a contentious one. Of course, it may seem obvious that you can engage in surveillance against your employees that are unionizing, but if you already have surveillance measures in place at your place of work, those can remain. Now, if there's specifics on this that you have questions about, we recommend that you reach out to your legal counsel. And of course, this wouldn't be complete without telling you you can't retaliate. So NLRB is really big on retaliation-based complaints. So we want to make sure that you're aware what are some examples that look like retaliation. Involuntary transfers, layoffs, termination. Some employees are filing complaints that an adverse work assignment is forming retaliation for being involved in the union, etc. I'm sure you're sick of hearing me talk. I'm going to give Joe a chance to talk soon, but first we have to get through health and safety laws. And no health and safety law presentation is complete without COVID. I know we're all sick of it, but it doesn't appear to be going anywhere. So one example is California's Senate Bill 114, and this essentially is providing for paid COVID sick leave. And for those of you in California, this is an extension of the SB 95 sick leave, okay? So, of course, it only applies to employees, and technically under the wording of the law is only in effect for a couple more months, with my caveat there, unless it's extended again, which we saw SB 95 extended. So here's the basics. although it just went into effect in mid-February, it does backdate to January. Employers only with 26 or more employees really are the only ones that have to worry about this. And it's only if you're unable to work or telework. So if your employee gets COVID and you can send them home to telework, they're not entitled to paid sick leave under this law generally. So there's 3 reasons for paid COVID sick leave. You're caring for yourself, you have COVID, your family member has COVID, and this is new on SB 114. You've got vaccine-related care. A lot of people got sick after vaccines and were not able to work. So here's the difference with this law. It's divvied up into 2 different batches. So your first batch really centers around quarantining, or if you're experiencing symptoms and need to get a test. And a big one here, that last block, if you're caring for a child whose daycare is closed, right? A lot of people did run into this. You can tap that 40-hour batch. Now, you get a separate 40-hour batch if you have essentially these positive results scenarios. So you've got COVID or your family member has COVID. You can tap these 40 hours. So we now have a documentation requirement that you may be required to prove through documentation a positive result for an employee or a family member. So we don't normally see that in other laws, but in this one, they have that stopgap. So California is not the only one enacting COVID laws. They're all over the country. This is an interesting law. Georgia just implemented a law that says, hey, state of Georgia or counties in Georgia, you cannot mandate in your city or county or statewide a vaccine passport in order to get into an event or make use of certain benefits. They can't require a vaccine passport. And kind of quite the opposite here in Illinois. We have a law that really allows an employer to take any measures to prevent the transmission of COVID and not be held liable. So that's a really overgeneralization of that law, essentially. But Illinois wants to make sure that an employer is really permitted to prevent COVID or transmission of COVID through any means kind of necessary. And in Virginia, they've extended the presumption that a death or disability as a result of a COVID infection is considered an occupational disease. And that presumption goes through the end of the year. We have a similar presumption in California as well. So there's more than just COVID-related activity happening nationwide, of course, to protect the health and safety of our citizens. As you know, the wildfire season is practically year-round in many of the western states. So we now have what we're seeing are smoke and heat protections. And this is interesting here. Oregon now has what's called a final rule regarding employee exposure to wildfire smoke. So it requires them to notify their employees if the AQI, the air quality index, reaches a certain level at their workplace, and to implement training. And then Washington also enacted a rule, just like Oregon's, with regard to wildfire smoke. Separately, Washington also has its own rule now on heat exposure for outdoor workers. So according to this new emergency rule, employers are now required to protect their outdoor workers from dangers of high heat and expand their access to shade and then increase those rest breaks. Okay, so we've got protected leaves of absence as well. We are seeing these not only throughout the states, but locally. So we'll get into a little bit more ordinances here. Now, the one state that really stood out was Connecticut. There's lots of activity going on. So Connecticut has instituted 3 new leave of absence laws in 3 different areas. The first one, kind of not surprising in light of the Dobbs Supreme Court decision. Connecticut now has a new protection for persons receiving reproductive health care services and a protection for those providing reproductive health care services. Separately, Connecticut is now allowing 2 hours of unpaid leave to go vote in special elections, and a lot of states have those protections. And then this is also a nationwide trend on domestic violence issues and protection for victims. Connecticut, like a lot of other states, now has a prohibition of discrimination against a victim of domestic violence and requires an employer to accommodate them, court appearances, leave of absences, etc. Also trending nationwide are paid leaves. So many states are saying, hey, it's not just enough to abide by the FMLA and provide some job protection upon their return. We want to pay employees to make use of their leave. And part of this is in order to retain those good employees, right? So Maryland has this new paid family and medical leave program that provides employees with 12 weeks paid leave. So although this legally went into effect in just this June, the employer contributions do not start on this law until October 2023, and the benefits are available January 1, 2025. So if you're printing out these slides and you're going through this later, when I say effective January 1, 2025, that means when the benefits are available. But there's other requirements that back that up that apply in 2023. So Maryland's law applies to employers that have 15 or more employees. And then separately, jumping down to that third bullet, Delaware has basically almost the same law. Now, that's legally in effect as of July, but again, benefits are not available for a year later here in January 2026. So the employer contributions on that Delaware law do not begin until October 1st, 2025. So Delaware has a little bit more time to plan, and Delaware's law only applies to employers with 15 or more employees. Lastly, New Mexico has just enacted their first paid sick leave law. So for every 30 hours worked, that employee gets 1 hour of paid sick leave. And this is interesting as well. So not only are municipalities and counties and states enacting their own paid sick leave laws, but we now have one enacted through an election. So June 7th, an election was held, and San Francisco created an ordinance with paid leave. So this new ordinance requires an employer to provide leave in the event of a public health emergency to employees. So there's a pretty specific definition of a local or statewide health emergency that pertains to contagious, infectious, or communicable diseases, and that has to be declared by the city or the state. And then separately, if the air quality index is really bad and an air quality emergency is declared by the specific Bay Area Air Quality Management District, and the issue is for the air alert, and you cannot work because of that, the paid leave statute here may kick in. So, and this is on top of the city's paid sick leave not pertaining to a public health emergency. So that is quite an interesting development as a result of the June election. So I am going to turn it over to my co-presenter, Joe Gbujama now. And Joe?
Thanks, Joy. Yeah, and so now I'll be taking this time to cover the next two sections. In this section, we'll be talking about anti-discrimination laws, specifically hairstyle discrimination and Crown Acts. And so in terms of Crown Acts, when we speak about hairstyle discrimination, the classic example would be something akin to the following. Let's say that there is a Black employee who is applying to a job and they have dreadlocks. They're applying for the job, they receive an offer, and the employer says, hey, we'd love to have you, but you need to cut your hair because our policy does not permit you to have dreadlocks. The prospective employee refuses to cut their hair, and so they don't get the job. Previously, what would happen is the employee would likely not be able to prevail because the court would say your hairstyle is not an immutable characteristic. You're not being fired on the basis of your race. It's on the basis of your hairstyle. Therefore, you can't prevail on a claim of discrimination. As a result of that scenario, we started seeing what has been referred to as Crown Acts. And so the Crown in Crown Act stands for Create a Respectful and Open World for Natural Hair. This was first passed in California in 2019, and since then, about 17 new states have passed these laws. And these laws are designed to prohibit discrimination based in employment, or discrimination in employment based on hairstyles and hair textures. And so I'll be highlighting the examples of 2 states and then speaking broadly about some of the updates that we've seen nationwide in regards to hairstyle discrimination. So the first state to cover is Maine, which recently amended their statutes to include a Crown Act. So under Maine's law, race includes traits associated with race, including hair texture, afro hairstyles, and protective hairstyles. The statute goes on to describe protective hairstyles as braids, twists, and locks. And this is effectively the entirety of the statute. As you can see, there are no exceptions, and that's something that we'll see in contrast to Tennessee in a moment. But as you can see here, it tends to be designed towards traditionally more Black hairstyles, but that's not necessarily inclusive, as we'll see in Tennessee. The Tennessee law, Tennessee's Crown Act, says that an employer shall not adopt a policy that does not permit an employee to wear the employee's hair in braids, locks, and twists, similar to the Maine law. But then it goes on to say, or in another manner that is part of the cultural identification of the employee's ethnic group, or that is a physical characteristic of the employee's ethnic group. And so as you can see, the 2 laws both protect the same thing in terms of discrimination in hairstyle, but the Tennessee law appears to be more broad, to the extent that, let's say a culture says that a culture values having long hair, and an employee wants to keep their hair long, but an employer says, hey, you have to cut your hair and keep it shorter. While the hair may not necessarily be, or the hairstyle may not necessarily be a lock, braid, or twist, to the extent that an employee can argue that having long hair is a part of their cultural identification, they may be able to assert that they've been discriminated against in violation of the Crown Act. One other difference between Tennessee and Maine's laws is that Tennessee's laws have exceptions. So the Crown Act does not apply to a public safety employee if it would prevent the employee from performing the essential functions of their job requirements during the course of employment. So an example here may be a firefighter or someone in another type of public safety employee, and having hair in a particular style may put them at risk, or it may prevent them from being able to perform the essential functions of their job. And there may be a need to, employers may be able to regulate their consistent with that policy. Another exception, the Crown Act, is a policy that an employer adopts to adhere to common industry safety standards to maintain reasonable measures in compliance with state and local rules and regulations for health and safety. And so when we look at Crown Acts nationwide, what we're seeing is that at the federal level, the Crown Act is passed at the House, but it appears to have stalled in the Senate. So we may very well see, time will tell, but we may very well soon have a federal Crown Act, but we'll have to see what happens. However, as previously mentioned, at least 17 states have currently passed Crown Acts or some form of variations. These states include California, New York, Virginia, Colorado, New Mexico, Connecticut, and most recently Illinois, amongst several others. Another thing to pay attention to is that even in states where they do not have Crown Acts, there are some local cities that are passing Crown Acts. So for example, Arizona does not have a Crown Act, but the city of Tucson and Tempe do have Crown Acts. Additionally, Austin, Texas just recently updated their law to include a Crown Act, despite the fact that this as a whole does not have a Crown Act. So please consult with your attorneys to make sure that you're in compliance with law and to make sure that to assess whether or not you have a Crown Act in effect in your jurisdiction. Now, for the next part of our presentation, we'll be focusing on a law that's the first of its kind out of Florida. There's a lot to unpack here, so I will be sure to try to leave space for questions if possible, but I apologize if we're not able to get there. And so what we'll be getting into now is Florida's HB 7. So this law is technically referred to as the Individual Freedom Act, but it's more popularly referred to as the Stop Woke Act. Stop Woke stands for Stop the Wrongs to Our Kids and Employees. One important thing to note is that this law has several parts, and it applies to schools and corporations in Florida. For schools, prohibits the teaching of critical race theory in K through 12 schools, and it prohibits school districts and colleges and universities from working with critical race theory consultants. Corporations, the law prohibits employers from creating, quote, a hostile work environment due to critical race theory training, end quote. And so here in this presentation, I'll be focusing on the requirements for just for corporations. The important thing to note is that the law restricts the content that public and private employers with 15 or more employees can use in workplace trainings. Specifically, Stop Woke Act prohibits employers from teaching 8 concepts based on race, sex, color, and national origin. And the way that this works in terms of procedure is that the law amends Florida's Civil Rights Act. So somebody who feels that they have been taught these taught any of these 8 concepts by way of a required training and work would be able to sue in the same way that one would be able to sue on the basis of race discrimination. And so the law defines unlawful employment practices to say that it is unlawful for an employer as a condition of employment to have any required activity that promotes, advances, or critically compels an individual to believe any of the 8 concepts that we'll be getting into shortly. Notably, this is not only restricted to actions that are done as a condition of employment. It also applies to trainings if those trainings are required for membership, certification, licensing, credentialing, or passing an exam associated with employment. And so for the next part, during the next 4 slides, I'll highlight the prohibited concepts in bold. And so the concepts that are in bold are the concepts that, if they are taught as a required training, potentially violates the Crown Act or the Stop Woke Act. And so in Florida, under this new law, if an employer hosts a required training that advances, promotes, or compels a person to believe that that members of one race are morally superior to members of another race, or sex or color or other protected class, that law is in violation of the Stop Woke Act. Additionally, it's also an unlawful employment practice for an employer to host a training that advances or promotes the idea that unconscious or implicit bias, that conscious or unconscious implicit bias is real. And so one example of what this type of exercise or one type of required training could look like would be if a training were to say, previously there was a study based out of Yale that took resumes where they were designed to be exactly the same, with the exceptions being that one resume had black sounding names, or one set of resumes had black sounding names, for example, Lakeisha and Jamal from the study, and then the other set of resumes used white sounding names, using Jamal and Greg, or using the names Emily and Greg. And when the study put these resumes out into the workforce and sent them to employers, the study found that the resumes named Emily and Greg were 50% less likely to receive, were 50% more likely to be called back for interviews. The study is used often to suggest that implicit bias is real. And so to the extent that this type of study or others, other exercises are used to promote the idea that implicit bias is real and as a required training for employers, those trainings and exercises may potentially violate the Stop Woke Act. Other prohibited concepts that are prohibited from being taught as part of required studies are the idea that privilege based on identity is a real concept, so that a person's moral character or status is either privileged is necessarily determined by their protected class, and the idea that being colorblind is not okay. And so one example of being colorblind and how this may come up in a training may be an employee comes up to a manager, or a training has a manager come up to an employee come up to a manager and say, hey, something that you said was offensive, and then the manager says, I'm not racist, I actually don't see color. If the training then goes on to advance the idea that it's problematic to say that a person doesn't see race because it denies systemic racism or the lived experiences of others, and that it doesn't acknowledge the way in which race can impact a person's experiences, that type of training could potentially violate the Stop Woke Act and subject an employer to violation of policies. Other ideas that would be prohibited under the Stop Woke Act would be any required trainings that promote or advance the idea or compel an individual to believe that they share individual responsibility for the sins of their ancestors, or that affirmative action is okay. And then the final two, and I apologize for skipping through, I will touch up on examples shortly, but I want to make sure that we can get through everything. The other two prohibited examples are that if a required training advances or compels an individual to believe that they should have feelings of guilt for the past actions of others, or that merit-based virtues are racist and or sexist, or that they facilitate oppression, those policies run the risk of violating the Stop Woke Act. Now, as I read off some of those prohibited concepts, and just as to state them off so that everybody has them, the prohibited concepts in order are that if a training advances, promotes, or compels a person to believe that moral superiority based on protected classes exists, that implicit bias is real, that privilege based on identity is real, that being colorblind is not okay, that individuals bear responsibility for past actions, that affirmative action is okay, that people should feel guilty for the actions of others, or that merit-based virtues are racist, those actions violate the Crown Act. Some people may be looking at this and saying, this seems unclear, and that is one of the issues that, that's one of the issues with assessing the law and determining how to proceed. The law does have an exception in that it says that any discussions that are part of a training course, these discussions can be had insofar as they are given in an objective manner without endorsement of the concepts. One thing that's been yet to see is how will courts interpret objectivity in this context. So for example, in the previous example, we mentioned a study for the that was used to argue that implicit bias exists. So in order to be objective, would an employer need to present an opposing study saying that implicit bias doesn't exist, or would an employer need to present a a study that critiques the study that was used in their example of implicit bias. These are questions that we don't have the answers to, and that time will tell to see how courts will interpret these provisions. Another question is, to the extent that an employer even raises the issue in the first place, or tries to speak on these provisions, can they be held to endorse them just by virtue of putting them on in the first place? Again, these are questions that will need to be answered. The Stop Woke Act has been challenged on several grounds. In fact, just 10 minutes after the Stop Woke Act was signed into law, a lawsuit was filed in the Northern District of Florida seeking an injunction based on First Amendment grounds. Specifically, it was challenged based on First Amendment grounds, saying for viewpoint restrictions based off freedom of speech, and for being unconstitutionally vague as to the prohibited conduct and as to enforcement. However, on June 27th, federal judge denied the request to enjoin the provisions of the act, and the law became effective on July 1st, 2022. And so as a result of this decision, it is likely that employers will need to refrain from sending messages to employees that could be construed as requiring employees to believe any of the concepts discussed, such as privilege, oppression, or that inherent biases exist that are premised on race, color, or national origin. And I will pass it back to Joy.
All right, I just wanted to let you know that we have only a couple minutes left in our presentation, but 4 slides if you can hang in there with us. So we want to make it through the rest of the content. We might run over just by a couple of minutes. So I also wanted to let you guys know that you will receive an email containing the full recording and the presentation slides, and we're going to do our best to answer all those Q&As in the chat. Those are really great questions, so we will have an FAQ out to you guys. There's a couple easy ones I could answer in there. Carol asked a question in the chat. Hey, how many spare the air alerts are we looking at for paid leave? Well, here's an idea to give you a sense. There were 46 spare the air alerts in 2020. That's a lot. But when you look to 2021, there's only 5. So you can really see it just depends on the fire season and a couple of other factors with, the weather. So if the AQI is above 100, the Bay Area District is going to issue a spare the air alert. The first one was just issued June 10th, so it's looking pretty good so far. And then someone else asked about that Spectrum Supreme Court decision. If Spectrum had a work-through written policy in place, why did they still get sued? And I wanted to just let you know that it was kind of a hybrid case. So they had a work-through policy, but it was not for the entire statute of limitations. So although they had that written agreement that said we'll pay you if you have to work through your meal break, it didn't apply to the entire statute of limitations, and the plaintiff got them on a period of time where there was no written work-through policy in place. So we want to give you a little heads up into kind of what's in the hopper for the rest of 2022 and trends for 2023. So let's see here. SB 1162, disclosures. This is a California law that is requiring pay data transparency for all employers with 100 or more employees in California, including staffing companies. Look at all of these classifications. You now have to disclose pay of all of these classifications in California, certain pay data bands, and here's what you have to disclose. This is not yet law. It is sitting in hearing. We anticipate it probably will get enacted, but here are the 5 categories of really rules of pay bands for what you have to disclose, and it is not just California. New York is all over wage transparency. So you've got 3 different ordinances, or New York and Ithaca, they have their own ordinances. It's an unlawful discriminatory practice not to disclose the minimum and maximum hourly rate of that salary for a position. and same with Westchester County. And then New York City on its own just amended their own wage transparency law to add positions for which a pay range must be provided. So that's it for our formal presentation. Thank you for sticking in there with us.
Well, thank you, Joy and Joe, and thank you, attendees, for taking time to meet with us today. Apologies for running right to the top of the hour. We will put together a Q&A response and get it out to you folks with all the other materials that we presented. And for those of you who are interested in meeting with us, please send an email to demo@ComplianceHR or click at the link box in your presentation box right now. Thank you again, and this is ComplianceHR signing off. Have a wonderful day, everyone.